Good evening and good to see all of you once again after a year's time. I am discussing today one of the subjects which I discuss often, and it's discussed also often with so many businessmen who I talk to, the role of institution arbitration in India. Of course, we've seen the growth of ad hoc arbitration in India in the past many years, but the emergence of institutional arbitration and some good institutions have come up in the past few years, and that is something which, in a sense, is good for India given how large a market it is and the kind of increase in disputes that we expect with the kind of investments that are going, particularly in infrastructure. You're looking at something like $250 billion of investment in infrastructure, and we've seen infrastructure, I would like to single out, generates a lot of disputes in India. But before I move on to the questions, there has been a certain kind of unhappiness that I witness in many promoters who I talk to, where they always tell me that, Tarun, I would like to remove the arbitral clause in the contract because it takes forever, that even after I have an award, it takes forever to enforce. So we discuss both sides of the coin today, and who better than all these experts who I have today who are in the thick of it. Let us start with Neeti, Sachdeva. Neeti, give me a good opening comment where you sum up the Indian arbitration scene in the past 10 years.
Thanks, Tarun, and thank you everyone who has sustained an entire day and is still here to listen to institutional arbitration. We'll try and make it interesting for you. I don't think I can get a better opening place to talk about institutional arbitration given that I represent an institution. And I'll pick it up from where Tarun left and said that he speaks to promoters who say that we want to remove an arbitration clause from a contract. I think that's the difference where it lies, and we have still not been able to differentiate the fact that when people say arbitration is not working, it's actually the ad hoc arbitration which is not working. Have they had a flavor of institutional arbitration in the last 5 years, 7 years, and 10 years? I think a lot of people in the room would have not had the same comment. Why do I talk about it? Just because I represent an institution? No. Because this is how disputes have been resolved worldwide, and unfortunately, India has lagged behind for some time. So if I was to summarize how things have happened in the last 10 years in the field of arbitration and institutional arbitration, I think it speaks volume that where our courts are criticized for being interfering in the process, we now have moved, the pendulum has moved to the other side, where we see the High Courts and the Supreme Court actually referring matters to institution to appoint arbitrators and to administer. Clearly it shows that there's a confidence in the process and that the process is working. But that is not as how we will see the future of institutional arbitration. We'll have to have parties agreeing to it. But I also have a caution. There was a report by Justice B.N. Sri Krishna. I'm sure everybody has spoken about it, threadbare and all. But one point which came out for me, which was also very surprising, and when I say surprising for me, because I always candidly say that all that I have done in the last 17 years is arbitration, so I know nothing else. And I was pleasantly surprised to know that there are more than 45 arbitral institutions in India. 45 is a number which many of us would not even have heard of sitting here. So the problem is that when you have that many arbitral institutions and not regulated in terms of their quality, the experience of every individual is different. And then you paint the canvas with the same brush and say, oh, it didn't work for me, it was expensive, arbitrator was not impartial, arbitration doesn't work. So I think we have made quite a stride in terms of promoting institutional arbitration. Our courts have done a lot, legislation has done a lot, but I think there is still a lot which needs to be done in terms of standardizing the process of how the arbitration should work in India.
Okay, but 45 is a number which I admit I had no idea. It is just too large a number for any country. I will, this question is to you, but two things. We don't have a very dedicated arbitration bar in India. We don't even see elevations to the court from the arbitration bar. Thirdly, we also witness that lawyers treat it as a weekend activity or a post 5 p.m. activity. These all are impediments to the growth of arbitration in India. Given that as a fact or the base where we start, where no elevations happen, so there is no motivation many times among the arbitrators that, they say, okay, we do arbitration, they also go to court. If you're dedicating yourself to somebody, but there are no elevations happening, which means that talent goes unrecognized. A great deal of talent goes unrecognized because there is no elevation. Who gets elevated mainly is people who appear in court. Mainly the arguing counsels many times is what we see. Give me a fair picture from your end of the spectrum, because you come from a law firm. You also interact with clients very regularly. Where are we headed? Where are we coming from in your experience?
Hi, good evening everyone. It's a very interesting question. In fact, just before we came in, I was talking to Neeti. Justice Som, who was on the panel of arbitrators in the Mumbai International Arbitration Center, has now become a judge. Yes? There is someone else who is a partner in one of the largest firms in Delhi. There are rumors or gossip which says that possibility of becoming a judge. So it is not as if people who are involved in arbitrations are not recognized. By and large, what happens is, today, the members of bar are appointed as arbitrators. Yes. They also practice in courts. Yes. So they appear before the courts under section 34 jurisdiction, 37. So they get recognized, and we are not too far away from those arbitration specialists getting recognition and also being called to the bench. Yes. So it's not a case where they're operating silos. Arbitration happens somewhere else. They're completely away from the courts. No. Arbitration and courts are closely interlinked. And arbitrators, unless they are completely professional arbitrators who are doing international arbitrations and they don't want to come into the judicial system, they may not be aware of. So it's always important that the arbitrators also make their presence felt in courts, and their ability to understand arbitration and also understand the nuances of the arbitration law will help them recognize and get recognition as a judge. So I personally feel that with these two things which are happening in the recent past, there's a trend that has started where people who are focusing in arbitration law and doing arbitrations can also be elevated as judges on the High Court.
There is no arbitration bar in this country.
Yes. True.
And these names you see which you have suggested, they are not just arbitration lawyers.
True.
They appear in
Courts regularly.
other matters.
Yes.
But there is no arbitration
Bar. Very true.
where elevation should take place.
You are absolutely right. Dr. Basim, you're right.
Can I just come in quickly? I totally agree with what Mr. Bhasid has said, and like I said, I've been now practicing arbitration for 17 years, and I think this discussion has just happened every single year. We talk about it, having an arbitration bar, why it doesn't happen. I think, Tarun, you have actually hit the nail on the head to say that you don't recognize arbitration practitioners to be elevated to be senior. You don't recognize them to be judges. It's good to have Som who's been able to do it, but as Mr. Bhasin said, he's not only an arbitration practitioner, but that's the nature of arbitration as well, right? The first reason people pick up arbitration is for its confidentiality. Yes. If you're going to be going out talking about this was my arbitrator, this was my counsel, this was my parties, then you have lost the confidentiality somewhere. I don't think it's only about becoming a senior or a judge. I think a lot of people, I can tell you, who are in the practice for about 25, 30 years now, are very happy to accept appointment as arbitrators and make that course, I would say, change of course for them from being arguing counsels to now sitting as an arbitrator. So we have to build an arbitration bar. It's slowly, definitely happening. Again, institutions play an important role, because I can tell you any institution appointing an arbitrator will not let that arbitrator work weekends. It's not acceptable. We take an undertaking, I can tell you, for MCIA and for every other good institution. We take an undertaking from the arbitrator on the number of hours they will spend in the next 6 months and during the week. It's in writing, signed by them. So that's how you have the process slowly changing and building up that bar.
Thanks for that input. I'll go to Roop. I want to know two things from you. In India, the problem sometimes also comes after the arbitration process. So you had a good arbitration process, and the parties have a good paper award which looks nice and well, but you don't get any money. Can arbitration succeed in a country where courts have a tendency to do justice in a matter. When judges sit with an attitude that, oh, I have this award, now let me do justice to it. So I'll sit in judgment over what has already been judged and adjudicated upon through the arbitral process. So now the Supreme Court, we have some good judgments coming, as Neeti also said, but India is so many states, and many times attitudes across states vary. That's why you see a lot of work gravitating towards Delhi, because it's qualitatively better, if I may say so. Your opinions on all of this?
Good evening, everyone. As far as arbitration to be effective, I think we...
You can take this.
Thank you. Good evening, everyone. I hope I'm audible now. As far as arbitration as a process is concerned, for this to be effective and for this to be more robust, we need to kind of restrict the intervention of courts under, of course, there are grounds provided under Section 34 of the Arbitration Act, but we need to also, as a matter of procedure, restrict the intervention for this to be effective. And as far as the companies or the promoter-driven companies are concerned, for them to get confidence in the process of arbitration, that's very important. When we come to institutionalized arbitration as compared to the ad hoc arbitration, I think the delivery levels are much better. So we are going to be evolving to that stage. It's a journey right now, but we will be evolving to the stage of, having a limited intervention as far as the courts are concerned. We need to look at the act where we can further limit the interventions and make it more robust and more acceptable. I think courts are already flooded with a lot of litigation, and if my vision around it is that we should be having more arbitrations and more institutionalized arbitrations, and some of the pending matters can be referred to the arbitrators. Of course, we have mediations, but then that's a way forward.
Okay.
I have something to add here. In my experience, see, places like Delhi, Mumbai, Chennai, Kolkata, the high courts, when they deal with 34, the attitude is different. But a lot of other places, the high court does not have original jurisdiction. Like take Allahabad for the matter. So even if you have a multi-crore award, if a 34 is filed before the district judge, they don't have, first of all, time for arbitration matters, because they hear bail matters, they hear other matters, and this is way down the list. Vakil sahab, ab baithiye, aapka case hear karenge. By the end of the day, they'll give another date. It's treated more like an appeal rather than an objection to an award under 34, so that system where, be it Karnataka, be it Andhra, every other state where the High Court does not have original pecuniary jurisdiction, and where 34 lies before the district court, there is still a huge challenge, because the kind of awareness to the arbitral system, what we have in Delhi, Mumbai, etc., is not there at the district court levels across the country. So that's where, even if you have an award within 18 months, 6 months for completion of pleadings, 1 year for closure, yet after the award is passed, that's what you said, the 34 challenge begins, and it takes 3, 4, 5 years easily.
Can you hold it here for a bit? You said district courts. If high court judges are sitting, as arbitrators, and then then the appeal is heard by a district court judge, do you think there is some fallacy in that process there, or you're okay with it?
I'm okay with it. See, the issue is the district judge would not even know the background, the reputation of the retired high court judge who was an arbitrator.
Yes.
He only looks at the award as if it's an appeal against a lower court decree. The mindset, the attitude is such that, no, this is an arbitral award, this is a time-bound process, it must be resolved. That culture has to soak in.
You said culture, and I have an anecdote to share. I'll not give names. I'm very happy that institutional arbitration is succeeding in India, because recently in an ad hoc arbitration where there was a single arbitrator, he came with two of his childhood friends who said they want to watch how I work. And one of the arguing counsels objected to it. The arguing counsel was very angry. We had coffee at the Oberoi right after he was, he had an altercation with the judge. A date was given. The next date, he brought his son while he was presiding and said that my son is not doing well in law. Let him learn how I work. The council again objected, saying that but sir, this is a confidential process. Your son can't be part of it. Again, he got a date. So we've seen such anecdotes, and then when we see institutional arbitration happening and the kind of standards that you bring to bear because what you're doing, can you also speak on that? What institutional arbitration is doing for India, Neeti?
Definitely, Tarun. I'll just answer your question on a district court judge looking at a matter of a high court judge. I think that's the fallacy of the thought process itself, right? When we say somebody sitting as an arbitrator, it's devoid of what their position was or is. They're just an arbitrator. And an arbitral award coming out of it needs to be looked at whatever court it is. In fact, Mr. Bhasin is here. I'm very proud to be a part of CIAB as well. And the Chartered Institute of Arbitrators is doing such a great job to have arbitrators trained. Right? So MCIA now has 83 matters, and I can tell you very proudly, except for 2 matters, we have not had a retired judge in any of the matters appointed as an arbitrator. Nothing against them. They do an absolutely fantastic job. But it is not that a retired judge is always required to be sitting as an arbitrator. We get matters on shareholders' dispute. There are technical infrastructure matters. You don't always need a retired judge to be listening to it, right? You need an expert who understands the business. And with that, like I said, CIAB is doing a great job, because whenever we have to appoint an arbitrator outside of a retired judge, it's just so easy to see that there's an FCIAB, a standard which is made, and that is where the institutions come into play as well, right? I think one of the biggest, it's a cliche, but it's true, is that your arbitration is only as good as your arbitrator. And half your battle is won if you've got a right arbitrator to manage and man it. The difference is that, and to everybody in the room here as well, we always say we are very happy to appoint new arbitrators. You may have the knowledge of the field, but having the knowledge of the field and to write an award are 2 different skill sets. Yes. What the judge sees in the court is your award. So courses like CIAB, courses like award writing practice actually prepare you from that transition of knowing the subject, knowing how to interpret the law, to making sure that you write an award which is not challenged in the court. The second point, I think, which an institution plays very important is that we are the repository for how an arbitrator has reacted. And I'll give you an anecdote here, an issue that we faced. There was a very high-profile matter which we got as an MCIA. It was a contract which had an MCIA clause. And our rules say that each party can nominate an arbitrator. The presiding arbitrator is always appointed by MCIA. Now the reason again was this, because we want to come out of that pale, male, stale arbitrator problem, right? You need to have newer arbitrators. So claimants nominated an arbitrator and sent a disclosure form to us. As a matter of process, we reach out to the arbitrator again and ask them to disclose within the availability of time as well. The arbitrator came back and said that there is no conflict. Whereas I was well aware personally as well that the same arbitrator has been appointed by the same party at least 10 times in the last 1 year. Now what do? I picked up the call very politely, a retired judge of Supreme Court, very politely, and I said, sir, your office may have missed it, but if you've been an arbitrator more than thrice in the last 3 years for the same party, we have a law which restricts it to doing. Would you mind just please checking and getting back, because we don't want an embarrassment for you or for us. Within 15 minutes, we had the arbitrator recusing himself, right? Which wouldn't happen in an ad hoc arbitration. So that's the institutional knowledge which comes into, and also the arbitrators feeling that if today they don't do this, their reputation is going to be at stake. So I think that's where institutions play a very important role.
Thanks for highlighting all these points. Many I didn't know about. Roop, one thing that I want to ask of you is, the recent glaring statement was made that arbitration is seen as an extension of the litigation process in India. Because many times in disputes where banks are involved at a level, for example, infrastructure companies, where everything is financed, And the amounts involved are huge, so even a day's delay is a big number. How do we get out of that reputation? Because many times the interest cost is more than the award cost. It has now become a commonplace. What is the way out? You are somebody who deals with this on a day-to-day basis.
See, it all depends upon how serious is the arbitrator in completing the arbitration process within a timeline. If the 6 months and 1 year timeline is adhered, then you can always wrap up the arbitration, and you win or lose. The amount is known, the interest, again, how do you stop the ticking of interest? Yes. That's extremely important. In fact, recently we were doing a lot of research for a matter. There is one Supreme Court judgment, yes, that's one stray judgment, which says that if the judgment debtor pays into the court the decretal amount, it is an amount paid on behalf of the decree holder, and therefore the interest will stop. Whereas there are several Delhi High Court judgments, Bombay High Court judgments which say the other way, the interest continues to tick. Even if you pay the money in the court, the interest doesn't stop. So the best way forward is allow the decree holder to withdraw the money, subject to terms that he will plow it back within 15 days if he loses. That's the best way. And even the CPC says that once you deposit the money in the court and order, even you give a notice that this money stands deposited, then your interest liability stops. So your interest liability stops if you give a notice after depositing the money in the court, or if the other side withdraws the money, subject to terms, then again your interest stops running. Interest alone, and when we did research, the award can be a few crores. The interest runs into 100 crores, yes, 200 crores. Yes. So in fact, that's the best way. No one realizes that the interest is ticking. Everybody keeps fighting till Supreme Court without realizing that the cause of action started 15 years back. So the award will always say from the date of cause of action till the payment. And that becomes a huge, and that can be something which can really pull the corporate debtor down.
Yeah, I mean, this is a worrying sign for a country where a lot of infrastructure investment is happening, and a few such incidents where I see is that the bidding cost can go up as a factor because you're building in that cost into your bid, because you feel that, I may not recover my money, so let's build in that cost into the L1. So your basic input goes up for every contract. That's a worrying thing. We'll be paying much more for the same infrastructure creation. That is, but I think the television tells me my time is up. I would have loved to chat with you all more on this. Maybe we'll get to do that offline, but I appreciate that all of you made time, joined with us, and the audience. Dr. Lalit Bhasin wants to say something.
This is one of my favorite topics because I do firmly believe that in India, arbitration has not taken off. It is mainly due to the fact, as Neeti rightly said, lack of good institutional arbitration centers. You said that many centers have come up. No. Yeah, you can count, say 45, but which are active? Which are those institutions which inspire confidence? Every institution is not like MCIA. Government has also set up, some council and all those things. But it has not taken off. We had the earlier one set up by Mr. Bhardwaj, the late law minister. The building was very good, but there was nothing inside the building. No proceedings were taking place. So MCIA is an exception. Yes. And so are a couple of other, Nani Palkiwala Center and all that, very respected. Therefore, when you have ad hoc arbitration, it is monopolized, cartelized by retired judges. The arbitration has become very, very expensive. One full day is split into 2 sessions, 2 hearings.
So double fees.
Yeah, double fee. So it is good, for the retired judges, possibly good for the lawyers also. They would also earn the same fee. But is it good, for
the client,
dispute resolution? This is not good for dispute resolution. Disputes are, you see, pending 5 crore cases. Law Minister made a statement on Friday, out of which 80,000 cases are pending in Supreme Court, 61 lakh cases pending in the High Courts, and 4 crore cases pending in the district courts. So where is our system of administration of justice? Can arbitration be? No, unless you have good institutions. When there is a dispute between two parties in India, they would prefer to go to Singapore, or they would prefer to go to Dubai to have that. And when we talk of arbitration bar, there is no arbitration bar.
That is a worry.
No, that is not the worry. But why there should be an arbitration bar? Why? That means that only confined to lawyers. There can be other experts, as Neeti rightly pointed out, who can be not only very good presenters of the cases, if technical matters, who can be very good arbitrators also.
Yeah, because recently in a sniff and tell arbitration for basmati rice,
Yes.
you had somebody who could sniff the rice and tell what quality it is. It was an export dispute.
Therefore, arbitration should not be just, you see, localized with the retired judges and lawyers. You have experts, bureaucrats, engineers, architects, chartered accountants. They should all form a part of this. Only then we can come to this.
In a lighter vein, can I make a comment before I end? One arbitrator once told me, Tarun, the expert is a very dangerous person. When he has to arrive at a certain figure, he says, "Aap mujhe figure de do, I'll arrive at that figure and present it before you." So, but that's a comment in lighter vein. Thank you.
And which O'Brien did you have the coffee? O'Brien's Act or O'Brien? That's a joke between me and Tarun.
He's got a very wide jurisdiction.
I like to thank each one of you for making time and coming for the panel. Thank you. Thank you all.